It's 12:05. Hello, everybody. Good morning, good afternoon, or good evening, depends on where you are. And welcome to Vural Center for Global Islamic Studies new episode on guest lecture series. I would like to welcome you all on me and Peter Mendeville. My name is Huseyin Yilmaz, the research director at the center. Today we are hosting Saadia Yacoob from Williams College. We are very happy and honored. Saadia Yacoob is assistant professor of religion at Williams College. She holds a PhD in Islamic Studies from Duke University and an MA from the Institute of Islamic Studies at McGill University. She has also studied Islamic law in Egypt and Jordan. Her research focuses on gender, childhood, and enslavement in Islamic law. Her forthcoming book, manuscript titled Reading Gender in Early Islamic Law, investigates the intersections of gender, age, and enslavement in the construction of legal personhood in Hanafi law. More broadly, her research interests include Islamic legal history, Muslim feminist studies, history of sexuality, and slavery studies. Her research has been published in the Oxford Handbook of Islamic Law and several academic blogs such as The Imminent Frame and Contending Modernities. She's also a curator, host of the History Speaks stream at the Maidan podcast, about which the editor of Maidan, Ahmed, will give a bit more information at the end of her talk. So we are very happy to have Saadia Yacoob in this guest lecture series episode. Floor is yours, Saadia.
Thank you so much, Huseyin, for that introduction. Let me just share my screen with you all. All right, hopefully you're able to see the PowerPoint.
Yes, we see it.
Wonderful, thank you. I'd like to begin by thanking Peter Mendeville for the invitation to speak, and to the Vural Center of Global Islamic Studies at GMU, also for the invitation, and also want to thank Aisha Noor for all the organizational work that she puts into making these events happen. So my talk today, I want to think about this question of legal personhood in Islamic law, and present to you all some of the work that I've been doing in my book manuscript that Huseyin mentioned, trying to think about this question of gender and legal personhood in Islamic law. So the question of women's status in Islamic law has been a burning issue in the past 100-odd years. From academic to confessional Muslim literature, there are two main arguments that have been made about women's status in Islamic law. One is of the complementarity of gender, and the other of a subordinated and disadvantaged status. To demonstrate the first argument about complementarity, let me turn to Jamal Badawi's book, Gender Equity in Islamic Law, Gender Equity in Islam, Basic Principles. I use this as an example because of the expansive reach of the book in English-speaking Muslim communities around the world. Published in 1995, Badawi's book is one of the most widely read English language texts on gender relations in Islam, written with the goal of clarifying misconceptions about the relations between men and women in Islam. Badawi argues against the term equality, which he argues is an absolute equality in every aspect of comparison, rather than what he is trying to argue for, which is overall equality. He prefers instead the term equity because it connotes justice and overall equality in rights and responsibilities assigned to both genders, allowing for variation in specific rights provided that there is overall balance and equality. While there might be particular aspects of the law that differentiate based on gender, Badawi's claim is that in the overall balance and assessment, the genders are equal in God's eyes. Gender differentiated laws for Badawi are justified through the argument that the roles of men and women in society are, quote, complementary and cooperative rather than competitive. Now, conversely, the scholar of Islam and gender, Layla Ahmed, argues that Islam continued and reinforced an increasingly patriarchal shift that was already underway due to Greek, Roman, and Christian periods that preceded Islam. Ahmed's historical account, which has been highly influential in the field, insisted on a tension between what she saw as the ethical impulse in Islam that was, and I'm quoting her, stubbornly egalitarian, and the developing orthodoxy that was not only hierarchical, but also decidedly patriarchal. Speaking of the development of Islamic law in particular, Ahmed argues, quote, Orthodox Islam, on the contrary, gave paramountcy as it elaborated its understanding of Islam into laws, to the practices and regulations Islam had enunciated, paying little heed in elaborating laws regarding women to the religion's ethical teachings, particularly its emphasis on the spiritual equality of women and men and its injunctions to treat women fairly. As a result, the religion's emphasis on equality and equal justice to which women were entitled has left little trace on the law as developed in the Abbasid age. For Ahmad, the status and autonomy of women was increasingly restricted as Islamic law developed and matured as a legal tradition. The question of women's status in Islamic law has been explored and nuanced by other gender scholars as well. In interrogating the legal construction of marriage and divorce, Kisha Ali has noted the relation between gender and slavery as categories of legal disability in Islamic law. These two categories, she argues, were not independent of one another, as marriage and enslavement were deeply connected in the juristic imagination of human relationships. Both enslaved people and women, she argues, were, quote, overlapping categories of legally inferior persons constructed against one another and in relation to one another, sometimes identified, sometimes distinguished, end quote. Despite the interconnectedness of these two categories, Ali argues that only gender is a permanent and enduring impairment to legal subjecthood in Islamic law. Judith Tucker has argued that women as legal subjects depend on the area of the law that you're looking at. Thus, while women's agency in economic matters was largely similar to that of men, in other aspects of the law, they had more constraints on their agency. So while women were recognized by the law as independent property owners, as a member of a family, a woman's agency was hampered by the interests of the family and patriarchal society. Depending on the legal arena, Tucker argues, the tension between the full and impaired legal agency of the woman was resolved by allowing the interests of a patriarchal society to supersede. Echoing Tucker's observation about the shifting legal agency of the woman, Marian Katz argues that while gender has a central role in juristic thought, and I'm quoting her here, gender and its attendant legal implications are deeply modulated by reference to other markers of personal and social status, end quote. In early Islamic legal discourse, Katz argues, woman was not a homogeneous category, but was mediated by other factors. Jurists thus assumed that women of different ages and statuses would take on different legal rulings rather than a consistent ruling by virtue of them being women. The different accounts that I have presented so far all attempt to understand gendered differential rulings in Islamic law, so legal rulings that are differentiated based on gender. Gender scholars of Islamic law have recognized the important role played by gender in legal discourse, while also noting a tension between the central role of gender and other social identities that also seem to be at play. In engaging with this body of scholarship, I see their object of inquiry as the question of legal personhood in Islamic law. In contributing to this ongoing conversation, I'm interested in exploring further this question about legal personhood to interrogate how individuals acquired legal personhood and subsequently how the rights and obligations of an individual were determined in Islamic law. In this talk, I focus on several case studies related to marriage in early Hanafi law. So early Hanafi law, I'm looking specifically at sort of 8th to 12th century, to argue that legal personhood in Islamic law was not tied to the gender of an individual. Neither man nor woman were legal persons in early Islamic law. And in the context that I'm looking at specifically in early Hanafi law. In my broader book project, I argue that legal personhood in Hanafi law was constructed at the intersection of multiple social identities, gender being only one of the identities in the complex matrix of social identities that defined a legal person. Thus, Hanafi jurists constructed the personhood of individuals not through a single category such as gender or enslavement or age, but instead at the intersection of these different social identities. Focusing on legal personhood rather than gendered legal rulings allows us to see how these different social identities work together. In this talk, I'll focus on, so that's sort of an argument that I'm developing more broadly in the book, but for this talk, what I want to focus on is the relational and situational aspects of legal personhood, to argue that the particular construction of a legal person acquired meaning and power only in relation to other legal persons. The legal personhood of an individual was constructed through their social relations. Legal personhood was also not fixed, but constantly shifting as the life circumstances and situations of an individual shift throughout their life. Rather than focusing on gender in Islamic law, I propose that we study the relations through which power was exercised. This approach would allow us to map the relations between different legal persons and how power functioned in each relation to establish a particular place in the social hierarchy for the different legal persons. Such an analysis is important if we seek to understand what factors shape an individual's legal status and subsequently their ability to claim rights and obligations. In order to do this, we cannot rely on a simple and static assessment of men as privileged and women as disadvantaged. This male-female binary fails to capture the complexity of how power and status function in legal discourse. There are, in fact, no single predetermined categories through which we can predict people's legal status or agency. So to better understand what I mean by the relational and situational nature of legal personhood, let us consider the power that was granted to the father and paternal grandfather to compel children into marriage. So I want to look specifically at this case study of marriage of legal minors in Islamic law, or in Hanafi law in particular. While Islamic law conceptualized of marriage as a contractual relationship between two parties, it did allow for one or both parties to be legal minors. And legal minors here are defined as those who had not yet reached puberty, which was marked for boys as nocturnal emissions and for girls as menstruation. There are moments where at least the Hanafi jurists do also describe one of the signs of puberty for a girl being nocturnal emissions. But generally they tend to go with menstruation for girls. So legal minors did not hold the legal agency to contract their own marriages, which had to then be contracted by the minors' guardians. Muslim jurists differed on who could serve as a guardian in this capacity. At its most restrictive, the guardians who could marry off a minor were the father and paternal grandfather, and this was the position held by the Malikis, the Shafi'is, and the Hanbalis. The Hanafis held the most expansive option, allowing the father and paternal grandfather, as well as other legal guardians of the minor, to also contract a marriage. Now, the power granted to guardians in contracting the marriage of minors was not a matter of representing the minor's desire in a matter where the minor could not act themselves. I mean, there are certainly, the jurists talk in this way where, which seems to indicate that maybe the minor themselves wants to get married, and usually they're referring to minor boys. And in that case, he would need the consent of his guardians. But the jurists were very explicit that the guardian also carried the power to compel the minor into marriage. The minor's consent then was of no legal consideration in contracting such a marriage. The difference between the marriage contracted by the father and paternal grandfather versus other legal guardians was manifested in the ability of the child to exit the marriage. In marriages contracted by the legal guardian, the law allowed the child to exercise a right of rescission known as khiyar al-bulugh at legal majority. The marriage contracted by the father and paternal grandfather, however, was not subject to rescission. Instead, the minor child would have to wait until legal majority to exercise their right of divorce in the case of a minor groom, or petition for divorce in the case of a minor bride. The extensive powers given to the father and paternal grandfather with regards to the marriage of minors was embedded in the juristic assumption that these two individuals were of sound opinion and had the child's best interests in mind. Despite the fact that historical records show that mothers routinely arranged marriages of their minor daughters and less so of their minor sons, Hanafi jurists assumed that the mother might have a child's best interests in mind, but could not be relied upon to make sound judgments in establishing these new kinship relations. The jurists granted such expansive authority to the father and paternal grandfather that even if they made seemingly unsuitable or incompatible matches, the marriages that they contracted could not be voided. While both the father and paternal grandfather were sexed male, the authority of compulsion granted to them was the effect of the father-child relationship rather than simply an effect of their maleness. Certainly, if we look at the juristic determination to grant the paternal grandfather greater authority than the mother in contracting these marriages, it would seem that it's maleness that is shared between the father and paternal grandfather that confers this authority, right? I point to the relational aspect of this authority, however, not to downplay the gendered nature of authority. There's certainly a kind of gendered element that's happening here, but to urge us also to consider that this authority is neither essential to individuals who are sexed male, nor is it acquired by all men. If we analyze this authority given to the father and paternal grandfather as one granted to legal persons who are sexed male, then there are several discrepancies that we'd have to account for. The most obvious of these is the fact that the minor son was also subject to compulsion in marriage. While marriage of minor sons was perhaps less prevalent as a social practice than the marriage of minor daughters, as a matter of legal principle, the minor son's maleness did not grant him the self-determination that would protect him from compulsion. Similarly, the law did not recognize all fathers as patriarchs. Enslaved people, for example, could not exercise authority over others in society, or other free people in society, or even other enslaved people, and thus could not serve as guardians. As an enslaved person then, the enslaved father was neither a patriarch of a family, nor did he carry the legal capacity to exercise authority over his children. The law recognized only free fathers as carrying the power and authority of a patriarch. The free father was not only seen as holding authority over his children, but also had a vested interest in the family and controlling the kinship relations that were established through marriage. As the father of a son, the paternal grandfather also held the position of patriarch and was equally vested in the decisions regarding the family. The paternalistic ethic of care that governed the father-child relationship assumed that paternal instincts would prevent the father and paternal grandfather from making decisions that would harm the child's welfare. The child, however, is also a member of this family network, and as such, the marital decisions that were of benefit to the family might also be seen to be in the best interest of the child. So those two are sort of connected to each other. It is for this reason that, unlike the legal guardian whose marriage decisions could be scrutinized, Hanafi jurists did not make a similar provision for the marital decisions of the father and the paternal grandfather. The father and paternal grandfather's authority and power is thus only acquired when a particular relation is established. That is, once a man is married and becomes a father, and subsequently when his own sons have children, right? And this is particularly for free individuals. This paternal authority is also curtailed to that relationship alone and does not extend to all the relations that an individual is embedded in. What I mean by this is that the free father as patriarch exercises this authority only in relation to particular legal subjects, that is, his minor children. While he also held authority as a husband and an enslaver, so if he had the financial means to purchase slaves, he would also then have this capacity as an enslaver. Those relations might share some aspects of paternal authority and yet differed significantly in other ways. While we might be tempted to see children, wives, and enslaved people all as dependents, each one of these was a unique form of dependency that constructed unique legal personhoods, creating for different modes of legal agency and power relations. The legal personhood of father and minor child then are relational and mutually constructed, acquiring meaning only in relation to one another. Thus, a change in the father and minor child relation to the father-adult-child relation also shifted the legal agency that was ascribed to both individuals. As a free child approached puberty, they entered into a liminal stage defined by Hanafi jurists as prepubescence, so murahaqa is the term that the jurists use. In this liminal stage, the free child began to acquire greater rights of self-determination. Thus, they could contract their own marriage, with the marriage being suspended until the guardian expressed their consent. Hanafi jurists also allowed for a free prepubescent child to begin engaging in commercial transactions under the supervision of their guardian so that they might acquire experience in handling financial matters. In this liminal stage, the free child was being socialized to enter into the world of free adults. Upon reaching legal majority, the free adult child, whether male or female, could no longer be compelled into marriage. And some of this is particular to Hanafis who would not, who allow women to, contract their own marriages when they reach legal majority, even if they are virgins. As a free child came into legal majority, they entered into the social world of free adults and thus acquired greater legal agency. In a world where the ability to procreate and fatherhood were markers of increased social status, puberty marked a free minor boy's entrance into the social world as a potential patriarch. As a 12th century Hanafi jurist Ala ad-Din al-Kasani argued, nocturnal emissions mark the boy's ability to procreate, which allows him to move from the domain of children into that of fathers. For a free minor girl as well, puberty marked the possibility of marriage and procreation. If she was already married, consummation and moving into the marital home marked a shift in her legal personhood, granting her greater social status and autonomy. So this is the sort of virgin and non-virgin distinction that, that jurists make between women who are married or women who are unmarried who might be virgins, and then women who get married and are no longer virgins. The right of compulsion in marriage granted to the father and paternal grandfather demonstrates the relational nature of legal personhood. This power and authority granted to the father and paternal grandfather was not by virtue of their maleness, but instead came into effect only through their relation to their minor children. This position was also not granted to all fathers, but only free fathers who could take on the position of a patriarch. The legal inability of the minor to exercise self-determination was also not a condition of every relation in the minor's life, but instead confined to the father or paternal grandfather and, in the absence of the father or paternal grandfather, legal guardians. As the minor reached legal majority, a change was also affected in the relation between father and child. The relational nature of legal personhood also meant that individuals occupied multiple legal personhoods at the same time, depending on the different relations in which they were embedded. For an individual to occupy multiple legal personhoods meant that the intersectional configuration of social identities that shaped an individual's legal personhood was not an essential aspect of an individual, but instead dynamic and constantly shifting. As Patricia Hill Collins argues, scholarship on intersectionality has helped us recognize that individual identities are not only intersecting, but also performative, changing our conception of identity from something that one has to something that one does. Identity then is not a fixed essence, but instead something that an individual carries with them from one situation or one social context to the next. Stuart Hall argues that, quote, identity is not a set of fixed attributes, the unchanging essence of the inner self, but a constantly shifting process of positioning. In fact, identity is always a never completed process of becoming, a process of shifting identifications rather than a singular, complete, finished state of being. Theorizations of identity as performative, positional, and a continual process of becoming are helpful in grasping the relational nature of legal personhood in early Hanafi law. First, it points us to the fact that identity is not simply a personal matter, but is shaped by social structures, and in our case here, the legal system or legal discourse. These social structures not only create identities as a vehicle through which power relations are exercised, but also provide the conditions that result in the internalization of these identities by the individual. Secondly, it demonstrates that identity is shaped by multiple factors and shifts from one social context to the next. This allows us to see that identity is not essential to the individual, but instead something that is acquired and also differentially performed based on shifting context and social relations. So to demonstrate this point, let us turn to the free adult wife as a particular form of legal personhood. As a free individual, the free adult woman had ownership over her own sexual commodity and had the self-determination that allowed her to contract her own marriage in the Hanafi legal school. Neither the free minor girl, or the child, nor the enslaved adult woman or the enslaved female child had the legal capacity to exercise such self-determination. Both the free minor girl and the enslaved adult woman could be compelled into marriage, and neither could exit that marriage until emancipation in the case of an enslaved wife, or legal majority in the case of the minor bride. The free adult woman, on the other hand, acquired self-determination both through freedom and legal majority. Now, there are particular restrictions to this in that the Hanafi jurists would allow the family members to contest the marital decision of a free adult woman if they felt that she married somebody who was not a compatible spouse. Once she married, however, the free adult woman acquired the legal personhood of a wife, a relation that required her to take on a subordinate position, obey her husband, and relinquish her sexual autonomy and mobility. The free adult wife as a legal person, however, was only constrained in her legal agency and autonomy in relation to their husband. She did not carry the legal personhood of a free adult wife in all of her relations. As a free adult woman, for example, she had ownership rights and as such could be an enslaver. In her relation as a female enslaver, then, she exercised power and authority over the people that she enslaved. As Keisha Ali has mentioned, femaleness certainly constrained the position of the female enslavers. So there are particular differences or differences in the rights of ownership between male and female enslavers. She could not, for example, make sexual use of enslaved men. Where early sources mention instances of female enslavers interpreting scripture to claim such a right, there was no hesitance in intervening in a manner that violated her ownership right. While femaleness was certainly at play in the position given to a female enslaver, we should be hesitant to read this femaleness as a shared identity across the female enslaver and the enslaved woman. Like male enslavers, female enslavers were also oriented towards enslavement or towards towards slavery and slave trade as a relation of property, and were invested in enslavement as both an economic advantage as well as a means of acquiring authority and social status. By virtue of the enslaver-enslaved relation, the female enslaver exercised many of the same rights over enslaved people as male enslavers would. While she might not have been permitted to make sexual use herself of enslaved men, she still held ownership over the sexual capacities of both enslaved men and women. She could compel them into marriage, and any children born through an enslaved woman or through the women that she enslaved were her property. As both a wife and a female enslaver then, a free adult woman could occupy different legal personhoods at the same time. each one of these legal personhoods was relational and situational. That is, it was acquired in a particular relation and was tied to that specific situation. The constrained legal agency of a free wife was tied to her relation to the husband. As a female enslaver, she occupied a very different legal capacity, exercising power and authority over others, which in turn granted her admission into a particular sort of elite in society. Legal personhood in early Hanafi law did not reflect some essential and unchanging nature of the individual, but was instead dynamic and shifting. It was acquired by the individual based on their positioning in particular relations and was shaped by the context of that relation. As individuals exist always in multiple relations, this meant that an individual acquired multiple legal personhoods at the same time. The resultant effect of this was that no single legal capacity or legal agency defined an individual at all times or in each relation. The constraints that an individual carried in one relation was not carried by them in all relations. So the feminist legal theorist Nagari Nafeen argues that modern legal systems, particularly those emerging from liberal traditions, present themselves as impartial, treating all individuals equally regardless of their particularities. This legal person is ungendered, imagined as sovereign, self-legislating, and autonomous, unencumbered by relations of dependence. The modern legal person is seen to derive their rights and duties from personally chosen contracts. This frees them from customs and traditions, as well as familial relations and communal obligations that are not of their own choosing. This idea of the modern legal person is also understood to be universal, an abstraction that can be applied equally to all individuals. Feminist legal theorists have, of course, critiqued this triumphalist account of the legal person, arguing that women have never been allowed to be sovereign, autonomous, and rational subjects. They argue that the abstracted notion of the modern legal person is in fact based on an imagination of a social order in which only particular types of individuals can flourish. The legal person imagined by the law, Nafeen argues, is a middle-class white man, who is able to thrive in the competitive market. Such a man is able-bodied, autonomous, rational, educated, moneyed, competitive, and self-interested. Legal personhood in early Hanafi law was neither abstracted nor centered the individual as a legal person outside of their social, familial, and communal ties. In this legal world, personhood was constructed as both relational and situational. By relational and situational, I intend two things. Legal personhood was established, legal personhood was established based on the relation in question and was mutually constituted by those relations. An individual thus acquired legal personhood based on their social relations. And secondly, or B, legal personhood was dependent on context and situation. As situations and relations changed, so did the individual's legal personhood. The resultant effect of this was that legal personhood was not fixed, but dynamic and constantly shifting. The legal person in early Hanafi law was not an abstracted individual, but instead constructed through the social relations in which the individual was embedded. The legal person imagined by Hanafi law was not a self-determining and autonomous individual. Autonomy existed on a spectrum, with individuals acquiring greater or lesser autonomy depending on the relation. No individual, however, was seen as fully autonomous in the sense of being freed from their social relations or from obligation to exist in relations except through their own personal choice. Social relations were understood to be a fundamental aspect of human and social existence. The relational and situational nature of legal personhood meant that the authority and privilege, or conversely, the legal incapacity and subordination ascribed to the individual was not essential to them, but instead pertained to particular relations. The legal identity of an individual in early Hanafi law then was not fixed and static, but instead continuously in process. Thank you.
Thank you so much, Saadia, for this fascinating presentation. Now the floor is open for questions and very short comments, and I leave the management of QA session to Saadia. You can just unmute yourself and ask the question.
Okay, thank you very much for that presentation. Let me ask you, this is a pretty straightforward one, I imagine. Was the right of recession granted equally to the boy and the girl?
Yeah, that's a great question. So there seems to be a greater right of rescission of the girl because there is a recognition, well, no, let me backtrack that. So it depends on whether for the girl, whether the marriage was consummated or not. If the marriage was consummated prior to her achieving legal majority, then she would no longer have the right of recession. So she did, so when she came of legal majority, if the marriage had not been consummated, then she had the right of rescission. Now with the boy, again, the marriage would essentially be determined to be consummated based on his ability to consummate it, right? So there's certain kinds of gendered implications of this. The understanding seems to be that you could consummate a marriage with a minor girl as long as she was able to bear the penetration without physical harm. Whereas in a boy, it was dependent on his ability to consummate the marriage, his ability to penetrate. So there are gender differences, not so much in the right of rescission, but in the conception of consummation that then would impact the girl possibly in more negative ways than the boy.
Well, it's pretty interesting. I have a couple of questions about the right of compulsion. You mentioned that the mother's interest in the child's welfare could be questioned. I was just wondering whether you ran across any cases where the father or his father, where their interest in the welfare of the child, male or female, could be challenged, questioned.
Yeah. So the mother's, so there are two kinds of things that the jurists are thinking about. And again, I should sort of clarify that what I look at is legal discourse and not so much how these cases are playing out on the ground. So I'm much more engaged with what jurists are articulating sort of in the books about how these rights can be claimed or the way that they play out. So in the legal discourse, the jurists are concerned with two things. One is the concern for the child's welfare, and the other is your intellectual rational ability to make sound decisions. So in terms of the child's welfare, they see the mother and the father and the paternal grandfather as all equally having the same kind of care and concern for the child's welfare. Where they differ with the mother is on this point that she does not have the same level of sound judgment that a father or paternal grandfather would make. Now, the most obvious reading of that seems to be a kind of, a derogation of women's rational capacities. And there are certainly like prophetic traditions that people can draw on to make those arguments. I suspect that there's something else also happening there, which is that men are perhaps given greater right in determining what kinds of kinship relations are established through marriage for the family rather than the women. Right. And that then it's justified through this kind of argument about women not having the same kind of rational capacities. So in terms of the care for the child, they think mother, father, paternal grandfather, all in the same place. It's just this question of sound judgment. How this plays out on the ground, I'm not entirely sure. And whether there are court cases where a child or even the mother might have argued that the father and paternal grandfather made a really unwise marital decision, and whether those were voided or not, I'm not really sure.
Yeah, yeah, that's pretty interesting. And that what you say just kind of drives home another point, that in a fundamentally patriarchal society, you know how all the assumptions are going to run. Yeah, they run in favor of the men.
Right. I mean, to me, what's interesting is that they come in when there's particular work that argument is supposed to do, right? So when it comes to free adult women's commercial rights, right? Their commercial capacities and things like that, they're not making, the jurists are not saying that, well, women just don't have sound judgment.
Right.
And so you can't really give them control over their wealth, right? Somebody needs to be sitting there deciding at they make that argument about children, but not so much about free adult women. So,
Right.
you know, so for me, that then brings into question, when you see this show up, right, that women don't have the same kind of rational capacity, is it a statement about, you know, women's sort of something that's essential to women as opposed to that particular relation, right? And what they're trying to do there in terms of granting some people more power than others. And this becomes a convenient sort of narrative, right, to justify that.
Yeah, it certainly seems so. Let me ask you one more. Could the compulsory power of a free adult woman be, with respect to her enslaved people, could that be challenged? Could that be questioned?
The right of the female enslaver over enslaved?
Yes, yeah, the right of the female enslaver to determine, to force marriage on one of her enslaved people, male or female. Could that be questioned by anybody?
In the legal discourse, I have not seen femaleness of the female enslaver brought up as a reason to challenge her decision versus a male enslaver. Okay. Where you do see discussions come up is the question of, and this is across the Sunni legal schools, is whether or not she would be able to contract that marriage. So the Hanafis, because they allow free adult women to contract their own marriages, they say she, like a male enslaver, can also contract that marriage, right? The other legal schools don't allow free adult women, especially virgins, to contract their own marriages. So then they say, well, maybe, you know, they have different answers, like maybe her guardians could then be, but again, those are representatives, right? They're not necessarily they can't really step on her right of compulsion. They serve as representatives to contract that marriage.
Right, okay, well, thank you very much.
Saadia, Juliana Hammer has a question on the chat box. Perhaps I can read it. I wonder whether you can say something more about the distinction between minors and adults if, as it seems, the ability to engage in sex acts is not the determining factor. I guess I am also asking what the relationship between sexuality and gender is there.
Yeah, that's a really great question. Thank you. So the question about the distinction between minors and adults, it seems to me, so some of this I've been thinking about in terms of the medical tradition and their ideas about sexuality of men and women. So when I first read these juristic statements that said, well, you know, nocturnal emissions is also an indication of legal majority for girls, I was sort of a bit taken aback in terms of what exactly does that mean. And, you know, researching a little bit into the Muslim medical tradition, it seems that, you know, there are these ideas in which you know, in terms of bodily, there aren't such drastic or binary differences between men and women that, you know, that we might assume. And so there does seem to be the assumption that, you know, women also ejaculated. And you see this in some of the discussions that this 11th century Hanafi jurist Sarakhsi raises, where he's talking about how do you determine whether a minor girl who has been married, whether that marriage can be consummated. And, you know, makes this argument that what you have to look at is whether or not she can physically bear penetration, but then sort of goes on to talk about the fact that or goes on to talk in a way that seems to indicate that he does think that she could be experiencing herself sexual desire, but that in women, it's hard to know. So there's like different levels that I think I'm still trying to like work through in terms of these juristic conversations, where at some level, the sexuality of men and women doesn't seem to be very different. But at another level, there seems to be this argument that there's something about the sexuality of women that is unknowable as a legal object, right? That you cannot legislate based on it because it is not tangible in the ways that male sexuality is. So all of that to say that I appreciate your question. I think this is something that I still need to think about a little bit more.
I can ask a question here, perhaps, Saadia. Does this legal personhood change across sects or legal schools? What happens if two different legal schools accord different legal personhoods to the same person? So what happens? Do you have the choice in this regard, or do we have such like drastic differences across legal schools?
Yeah, that's a great question. So I think there's two kinds of elements there. One is this question of like legal systems as they were sort of playing out on the ground, and then the legal discourse. So in terms of the legal discourse, they generally tend to talk within their particular legal schools. And so, you know, the question of, let's say you have, you know, a married couple where one follows the Hanafi legal school and the other follows a Shafi'i legal school, I imagine they would have to decide between them which one they're going to turn to. You can't kind of take a little bit of the Hanafis and a little bit of the Shafi'is, right? You could sort of decide to go with the Shafi'i opinion, or you could decide to go with the Hanafi opinion, but you couldn't kind of bring a mix of the two. The question of whether or not on the ground this was possible looks different in different time periods. So in some time periods, we know that you know, the judges that were appointed were across the four Sunni legal schools, for example. And so people had the option of deciding to go, you know, to one particular judge over the other. In other instances, especially sort of later Ottoman period, right, we see clearly a privileging of the Hanafi legal school. And you see the effects of that into the contemporary period, where a lot of personal status laws in Muslim majority nations around the world are often based on Hanafi law, even though the population might not be predominantly Hanafi, right? So whether people on the ground could decide, so, you know, you might be Hanafi yourself, but you think that the Shafi option or the Hanbali option or the Maliki option is a better one for you, so you go to that judge, right? That depends, whether that was possible or not depended on time period. Miriam Shaibani has this really great article, I think that's come out, I can't remember if it's in Islamic Law and Society, where she's looking at a particular case in Egypt, where, you know, something like this sort of plays out, where you have a fight across two legal schools, and you have a judge who is making a decision based on his legal school on a marriage decision that was based on another legal school. And Miriam Shaibani does a really great job of both showing how that's, you know, sort of the cross legal school differences, you know, create this problem, but also that there's a lot more happening there politically, right, than just a problem of choosing one legal school over the other. So that's a really great article, I think, to look at, you know, to sort of think about how this played out on the ground.
I can ask another question. I'm teaching with together with Professor Hamdani a course on race and slavery in Islam, and some of the questions frequently come up is the legal personhood of certain people whose legal stand could not be easily categorized, such as eunuchs, which gender they are, whether they're slave or not, how they can, their social life, their property rights, their status, whether they are able to be a witness or judge, which occupations they can do. That's one question. Another is, this is specifically Ottoman, and I should know the answer, but I don't. There are devshirme. We have the recruits. They are not technically slaves, but they are also servants and deprived of certain rights. But I don't recall any legal discussion of it from Ottoman jurists. So do we have such discussions in legal literature about regarding the condition of such people in between in terms of legal personhood?
Yeah, that's a really great question. And I think it's one of the questions that's really been a burning question in terms of slavery and Islamic law, is this question of like, well, what exactly constitutes slavery, right? Like, what does it mean for an individual to be enslaved? And you don't really, at least in terms of the substantive legal documents, there isn't necessarily a kind of clear statement of this is precisely what it means to be enslaved. There also seems to be different categories of enslaved people in legal discourse. And not so much the kind of categories that that you're mentioning in terms of what you all have been looking at in your course, but more so the distinctions between somebody who is in a liminal space between being enslaved and being freed. So this could be somebody who has contracted with their enslaver that they will basically buy their own freedom, or it could be somebody where the enslaver has essentially stated that upon their death, this person will be emancipated. Then there's sort of the figure of the walad who kind of sits right in all of these discussions. So the walad is a enslaved woman who has born a child through the enslaver and acquires this particular status of walad. She is clearly still enslaved. Her child is free, and she is supposed to acquire her freedom once the enslaver dies, right? But again, there are ways in which the jurists are constantly having conversations about, does she get certain kinds of rights that a free wife would get, or is she treated like any other enslaved woman? So it seems like, I would say, at least in the early periods that I look at, the kind of like 8th to sort of 12th century, there aren't any clear statements about, this is exactly what it means to be enslaved, but there's seems to be a clear assumption that we know, right, what enslavement means, and that we know what kinds of incapacities it entails for people's legal agency. And then these discussions about different kinds of enslaved people who are both enslaved, but also somewhat in a liminal capacity. The question of eunuchs is a really interesting one. So Indira Gesink is working on this question of intersexuality in Islamic law, looking at substantive legal literature. And thinking about what's happening on the ground versus what's happening in legal literature or legal discourse is always interesting. So the eunuchs, at least in Hanafi legal discourse, which is what I look at, don't show up as gender ambiguous subjects. They are seen as men. And the jurists talk about them as men. They also seem to assume that there are some amongst the eunuchs who would still be able to penetrate. And so there needs to be an observation of the same kind of seclusion practices, with them. So it's interesting that, you can see that on the ground, there might be ways in which certain groups of people were seen as gender ambiguous or not fitting into that gender binary, but the law might treat them very differently. And then of course, there's the whole element of the fact that that social life is far more messy than what jurists right can deal with. And so what they do is they create these sorts of categories of who of how to kind of read all of this messy complexity. So the eunuch, for example, for them is still a man because, he is in possession or, was born as a man with a penis, right? And the question of what levels of castration, right, they have had to endure can depend, then sort of like shifts legal discussions of, what might be the legal obligations and things of that nature. But there's a very different idea of them as gendered subjects in at least Hanafi law than, what we might see in social history on the ground. Go ahead, Sumi.
Gotta unmute myself first. So that's fascinating that eunuchs are not considered another gender, that they're considered male, legally speaking. And in that case, I guess, well, I'm not sure if I can put this correctly, and I think it's just kind of flown out of my head, the wrinkle that I was thinking of, that if eunuchs are still considered male, how does that impact their function as guardians of female space or homosocial space? But, I'm sorry, I just, the thought left my head. Unfortunately, I was just captivated by that and was thinking immediately about something else, and it's flown out of my head. But because as Professor Yilmaz was saying, it has come up a lot in our class on race and slavery, because we've been spending a few weeks talking about different historical examples of eunuchs, and also eunuchs in the case particularly of the Ottoman Empire, where the Hanafi legal tradition most applies. This is what I wanted to ask. So a lot of the historiography about eunuchs and a lot of the studies about eunuchs, Marmons and Hathaways and the others, have really kind of, suggested that eunuchs are a conundrum, that they constitute possibly a third gender, or, that they, represent in their otherness individuals who mediate between sacred and profane, so on and so forth. If legally speaking, they're still considered men, that despite the emasculation of castration, if legally speaking, they're still considered men, why are we all wringing our hands about trying to understand their role in Islamic society? In other words, why are we talking about their genders, and why are we talking about, eunuchs as a kind of non-gendered group of people?
Yeah, that's a really good
remiss. Have we been remiss in not reading the legal literature? That's what I'm asking.
Yeah, no, I think that's a really great question. And there's sort of two things that come to my mind in relation to that. One is this question of, so I look at like early Hanafi laws, sort of 8th to 12th century. And certainly some of these issues around gender and sexuality shift and change over time. So, like in the early Hanafi legal text, for example, these discussions around whether enslaved women can cover in the ways that free women do, the Hanafi legal jurists are very insistent that they cannot, because that covering is a marker of that distinction between free and enslaved women. By some of the later period, we see a bit more ambiguity about this question, right? And some of these sorts of debates about, well, it depends on whether she's considered to be beautiful or not, and whether she's going to cause like, temptation in terms of her physical appearance in public spaces. So I think it would be, important to look at the Ottoman Hanafi discourse on like, sort of the law on, legal discourse. What were, Ottoman Hanafi scholars saying about this question? Because it might be that, by that point, it had become a significant enough of a practice that, they're engaging with this question very differently. In the early period, you see some of this show up. So, some of these early Hanafi legal texts, for example, talk about Malik Imam Malik, being posed this question about purchasing eunuchs, enslaved eunuchs, right? And Malik's response seems to be this kind of thing where this is a new sort of a thing. So he's kind of like, I don't think it's a good idea, but like there's this kind of hesitance of like, this is a subject that you are not quite familiar with. I imagine by the Ottoman period, this is a subject that is
big difference,
right? I mean, like prevalent in society. So their legal discussions around it might be different. The other thing it kind of makes me also think about though is is this question of discourse and the way in which we maybe connect discourse with social practice, the assumption being that discourse has a kind of power, to shape social discourse. And I think across several different aspects in the pre-modern Islamic context, we can see that discourse is saying one thing, and what's happening in social realities is very different. So I think there's something to be said about the fact that there's something about that kind of the nature of that discourse that might not that maybe we're misreading, thinking that there is a connection between the two, and maybe there isn't necessarily a connection. Maybe there's something about that discourse that could sit with certain kinds of ambiguities that maybe we're not being attuned to. And some of this reminds me of so in Pakistan, for example. So Pakistan in 2009 passed these laws around transsexual recognition of a third gender and rights of transsexual people. And so in the recognition of the third gender in Pakistan, the terms that they use are Islamic legal terms of khunsa and khunsa mushkil. So khunsa is the intersex individual, and khunsa mushkil is a intersex individual who's so ambiguous that you're not able to gender them. Khunsa you can gender, khunsa mushkil you cannot. And so what Pakistan has done is you can get this ID card that says you are male, female, khunsa, female, or khunsa mushkil. But the people that they're categorizing like that are not intersex, actually, right? The Khwaja Sira in Pakistan are not necessarily intersex, but there's a resistance to a politics of hypervisibility and definition that allows that contradiction to sit, right? Where people who are not actually intersex can be categorized as intersex individuals legally, while everybody, including the legal structure, knows, right, that that's not actually what they are. But what makes somebody Khwaja Sira is a question that doesn't really have an answer either, right? Because there's such diversity of practices there. So, so that's another example to me of like the way in which the legal discourse is saying one thing and it gets used to maybe justify certain kinds of social practices that are actually not at all what that discourse is talking about. And I wonder if there's similar kinds of things that happen in the Ottoman context.
Fascinating. I think Khalid wanted to ask something.
Question of abortion. So I was wondering what you found out through your research about abortion and what it implies about legal personhood. So abortion is one thing that I haven't really looked into. And it's something that I think in terms of Islamic law, there's very little work that has been done on this question of abortion. Marion Katz has an article about it. But other than that, I can't really think of much. So unfortunately, I can't really say too much about that. It would be a really interesting thing to think about is to what extent is the fetus seen as a legal person? And there are some ways in which the fetus certainly is, other ways in which there is a distinction made between life after birth versus life in the womb. But I can't say much more beyond that, sorry.
May I jump in with a quick question, Saadia, if I may? This was great. So my question is sort of, if you put on kind of the public intellectual sort of, hat, like two questions. One is, what has been most difficult for you to sort of maybe convey to non-academic audiences? And then the second one is, because you mentioned also Pakistan, like in different contexts, like the US context or Pakistan context, like is some of how you convey your material like becomes more challenging, or are there different layers of difficulty or intricacies involved?
Yeah, that's a really great question. Of like, how do you sit there and write all this stuff and then make it legible for a broader audience? I feel like, you know, the thing that I find works the best is to kind of introduce really material case studies and then sort of build from that. So that's generally what I tend to do with more public audiences, is to kind of, you know, bring in, here's a legal case, right? Like the jurors say XYZ thing. What do you know, what do you think that is happening here? Okay, we could read it this way, we could read it that way, but then this problem would emerge and that problem would emerge. And I think maybe, what if we read it this way, right? I think maybe this is what is happening, I think is the kind of way in which I have come to understand maybe the best way. Like it kind of gives people something to hold on to as a kind of concrete example that they're analytically thinking with. You know, a lot of academic discourse, I feel like, assumes that you have knowledge of a particular conversation that's been happening, situating yourself in it, bringing in other literature to sort of, you know, develop a very complex argument. Whereas I feel like in public discourse, you can't assume those things. You have to give people something very concrete. And also, you know, this is my sort of biggest struggle, is how do you decide which point you want to make? Because you cannot make all of them, you know, the way that you would in an academic context. And you certainly can't always make them with all of the nuances that you might in, you know, in a more academic space. So those, I think, are some of the things that I have kind of, how I've come to sort of think about it and engage with people on this. And then again, it depends on context too, right? If I'm in a Muslim communal context where people's engagement with the law is different than if I'm in a communal context where people don't know the law at all, or their assumptions about the law are entirely different, that also shapes very much what I'm saying to them and how I'm saying it to them.
Yeah, thank you. Thank you for that.
Thank you so much, everybody. I think we can slowly wrap up with Ahmed's, as promised, some informative presentation of the Maidan Sleeve podcast series, which involves Saadia Yacoob.
Yeah, I mean, I think, you know, in connection with it, you know, public intellectual and public looking scholarship, you know, portion, Vural Center for Global Islamic Studies received a grant from Henry Luce Foundation with the idea to develop a podcast that is fully dedicated to academic Islamic studies. And we've launched it. So it has 4 shows or streams in it. One is, you know, curated by our own, you know, Saadia Yacoob, called History Speaks, which features every 3rd Tuesday of the month. And I'll encourage you all to go and tune into the first one. I think Ashanur is populating the chat with the links. The other channels are by Nadira Mansour, by Suad Abdul Khabir, and by Armin Snanovic. And in addition to the 40 episodes that our wonderful curators will produce, the Maidan team will invite other scholars, and ourselves will produce another 10 episodes, giving us 50 episodes over 1 year. So the maidan.com/podcast. We hope that you will tune in there, and then on different podcasting platforms. We are excited about it, and we are working hard to make it as accessible as possible to broad sets of audiences. And thank you again to Saadia for agreeing to do one of these streams and doing such a great job with History Speaks. The first episode was just amazing. So we look forward to the next ones.
Thank you.
So thank you. Thank you so much, Saadia Yacoob. We hope to see you again as part of Maidan series, and everybody else in our next episode.
Thank you so much again for the invitation. Thank you.